Hello everyone, welcome to Amigos IAS. I am Adnan. The Supreme Court has reserved its verdict in a case that is challenging Directive Principle Article 39 Clause B and Fundamental Right Article 31 Capital C. So in this case, a lot of facets with respect to fundamental rights and their clash with directive principles have been discussed. So let's try to understand what this case of Maharashtra is about and what Supreme Court can take a decision in the upcoming future, guys. So let's jump into this particular case. So first things first, private property. Property is one of the most sensitive aspects, as we all understand. It was the most debated topic in the Constituent Assembly. And this property was a fundamental right which was mentioned in Article 31, which said no person shall be deprived of their property except according to procedure by the law. There was also fundamental right to freedom, Article 19 Clause 1 Clause F, which dealt with any citizen of India can acquire, hold and dispose property. But both of these were removed by 44th Constitutional Amendment 1978, and property has been made as a constitutional as well as legal right under Article 300 capital A. But this happened in 1978. So what is the case basically here? Title of the case is Property Owners Association versus State of Maharashtra. We will discuss details about this case shortly. Supreme Court is going to decide if private property can be considered material resources of the community under Article 39 Clause B of the Constitution. So here we have to understand first important aspect. When it comes to this fundamental rights and directive principles of state policy, we know that fundamental rights are justiciable in nature and directive principles are non-justiciable in nature. That means when you talk about the applicability of the fundamental rights, they have to be compulsorily be followed. Otherwise, we can approach the judiciary in case of violation of fundamental rights. Parliament also cannot make any law against fundamental rights. Article 13 says. DPSP's Article 37 says that these directive principles of state policy are non-justiciable. However, it is the duty of the state to apply these principles while making the law, because these directive principles are fundamental in the governance of the country. So there is a clash perspective which is there here, because what prevails over what is a matter of debate, which this case finally Supreme Court, hopefully it will decide, because it's a 9-judge bench. Okay, so if we go into this aspect here, of course, we understand fundamental rights usually have more precedence over directive principles, but the context of the 70s in India, where we have seen direct confrontation of the legislature with the executive, with the judiciary. So there we understand several cases also have come up, not only in the 70s, in the beginning of the Republic of India, when Government of India wanted to redistribute the land by bringing land reforms, by bringing Zamindari Abolition Act, by bringing land sealing acts by various states, property was impacted. So there we understand that Nehru has passed First Amendment Act 1951 and inserted Articles 31 capital A and 31 capital B here. So why this amendment was passed? There are so many reasons behind that. 15 clause 4 also was brought. Restrictions in 19 clause 2 were added. So several things came in this First Amendment Act. Out of that, the important thing is 31A, 31B for discussion now. 31A talks about saving of laws for acquisition of estates. Means 31 was in effect restricting the government from taking private property. Those who have excess land, take the property from them and give it to those who don't have property. And Zamindari Abolition Acts also were passed. Okay, and Land Sealing Act, which put a cap on how much land can a person hold. So 31A was in effect a kind of restriction on the right to property, where government can acquire land and it cannot be questioned in the courts. Okay, that means it allowed the government to take away the land even though you have fundamental right to property. But if in case still people question that, 31B was also inserted in the same amendment, and a new schedule, 9th schedule, was added here, which means 9th schedule is considered like a safety locker, because if you bring any law with respect to land distribution, okay, or land reforms, and because it may be challenged as it may violate the fundamental right to property at that time, to shield those laws from judicial review, Ninth schedule was created and laws were placed in the ninth schedule. Which laws? Those laws which were related to acquisition of property and land reforms. Those laws, if they violate fundamental rights also, it doesn't matter because they are placed in ninth schedule. Ninth schedule cannot be accessed by the judiciary. No judicial review exists. That is First Amendment 1951. Then, of course, we have several case laws again. If we elaborate discussion further, it may enhance the scope of discussion. But let me confine myself to only certain important aspects with respect to the case. We need to understand 25th Amendment Act 1971. There are so many amendments are there in between. Again, not relevant to our discussion 100% here. This amendment is important because this amendment inserted Article 31 capital C. Because in 1969, at that time, Government of India was trying to nationalize a lot of things, including banks. So banks nationalization was not accepted by the Supreme Court because you cannot take away private banks and nationalize it. What happened here was, there are some commitments to the government in the directive principles, which are 39 articles, especially B and C. What are these articles about? 39B says that the ownership of the material resources of the community, government can acquire that and distribute to others so as to subserve the common good. In simple words, government can take the material resources of the community and it can distribute that to others who do not have those resources. So as to subserve the common good means the public good is more important. Even if material resources are there in India, government can take those away and give it to those who don't have it. And 39 clause C also is there, which talks about the India's economic system should be such that there should be no concentration of wealth or means of production. Concentration of wealth, the production should not be resulting in what should not be in such a way that the economic system should not be such a way that this economic system, the concentration of wealth as well as this production, it should not be to the detriment of the people. Simply saying, we should prevent the concentration of wealth or the production in the hands of few persons. Now, these two, 39B and C, of course, they are directive principles, but there was no option. What happens here that they should prevail over this, fundamental rights, like 14 is equality, 19 is freedom, 31 is property. Indira Gandhi wanted to make these directive principles prevail over fundamental rights. So what she has done, 25th Amendment 1971 she has passed the amendment, and she created Article 31C to make these directive principles 39 clause B and 39 clause C prevail over fundamental rights 14, 19 and 31. Simply saying, if tomorrow the government is implementing 39B and 39C, fundamental rights, equality, freedom and property will not be considered. That means these directive principles will override the fundamental rights 14, 19 and 31. Means she has given precedence or importance to directive principles 39B and C. This is mentioned in 31 capital C. Then what happened? The story goes further here. Notwithstanding the fact that these directive principles are prevailing over this, then comes the case called Keshwananda Bharati case. In Keshwananda Bharati case versus state of Kerala, in this case, what happened is 24th Amendment, 25th Amendment, these were challenged. That means how much can the Parliament amend the Constitution as it wants? Because Article 368 gives Parliament the power to amend the Constitution. And can they make directive principles prevail over fundamental rights? Can they keep on amending the Constitution? That was questioned here. So this was a highest bench in India, 7-6 bench it was. Very narrow majority there was there. So these 7 judges, the majority judgment has said that, of course, 13 clause 4 means amendment is not equal to law. 13 clause 4 here basically means 13 article protects fundamental rights. That means government or parliament cannot bring a law against fundamental rights, but here fundamental rights are getting clashed. So Indira Gandhi was like, if I bring amendment to the Constitution, amendments should not be challenged for violating fundamental rights. If there is any law, if there is any bylaw, customs, usages, rules, regulations, those are mentioned in 13 clause 3. If they violate fundamental rights, then you strike it off. But if I bring amendment to the constitution, even if they violate the fundamental rights, I should not be questioned. That is why 13 clause 4 was inserted by 24th Amendment 1971. So let me clarify again. 24th Amendment 1971 was brought to make sure amendments are not considered as laws, and Parliament can amend the constitution which should not be considered if it is violating fundamental right as well. Then 25th Amendment was brought to give importance to these directive principles over these fundamental rights. And Indira Gandhi also has amended Article 368 to say that instead of procedure to amend the constitution, now it is called what? Power of Parliament to amend the constitution. She is emphasizing the importance of Parliament here. Now the other aspect what comes here is 368 Article Clause 3 also was inserted, and she has told that for the purpose of 13 Clause 4, okay, nothing in this amendment will affect 13 Clause 4. Basically saying Parliament has unlimited amending powers. This was challenged in Keshwananda Bharati case, and the 7-judge bench, okay, the 13-judge bench was there, 7 was the majority here. What they have said is, of course, 13 Clause 4 is valid, no problem with that. Parliament can amend the constitution, that is no problem with that, and they can, they can have this power. But the point is that there are some basic features in the constitution which even 368 will not give power for the Parliament. Means, in this case, even though 24th, 25th amendments were considered as valid, but the court has put some restriction on the Parliament that even if you have majority, doesn't matter. There are some basic features which even Parliament cannot amend. A new doctrine in India has come called as basic structure doctrine. Okay, what else happened after this? Many things, of course. Then 42nd Amendment 1976 was emergency period in India, and this was the amendment she has passed, which was called mini constitution. In this, notwithstanding the fact that 31 capital C gave importance to 39 B and C, what Indira Gandhi has done is, what the government has done is, okay, they made all directive principles prevail over fundamental rights 14, 19, 31, which means not only 39 B and C, any directive principles for the sake of welfare or socialism in India, they have to be implemented, and even if they clash with fundamental rights 14, 19, 31, they will prevail over the fundamental rights. Now, this was challenged in Minerva Mills case. In Minerva Mills case, okay, I just lost space here. Minerva Mills versus Union of India, 1980 case. In this case, this was challenged, and what the court has said, the court has struck down the part of 31 capital C, which has given precedence to all DPSPs over fundamental rights. Now, this is under question in Supreme Court. Why? Because when you say 31 capital C earlier, it was 39 BC prevail over 14, 19, 31. Now, of course, by the time Minerva Mills case has come in 1980, right to property was gone in 1978 itself. So, this case, what we need to understand is, do all DPSPs prevail over 14 and 19 or 39 B and C as the earlier 25th Amendment? There is ambiguity in this provision, which now the Supreme Court has to clarify. So, a lot of debate was going on in the 5 days what the court has heard. Of course, in April ending, the court has reserved its order, and last May 2nd also. So, we are waiting for the final verdict. What happened was, this case started with 39B, can the government take away the material resources, which may include property of others also, to give it to others for the sake of common good. From there it started, and the question now came to 31 capital C, whether Minerva Mills case has struck down the entire 31C or only that part which has told that all DPSPs prevail over the fundamental rights. So, arguments I was just going through, the opponents are saying that Minerva Mills case has totally cancelled 31 capital C. Others are saying, like government lawyer, Solicitor General Tushar Mehta has said that we have to use doctrine of revival. Means what? If courts are able to struck down any part which is introduced, the earlier part, whatever is there, that will be revived. Example, NJAC, National Judicial Appointments Commission, was a body which was created regarding the appointment of judges in India. This was supposed to replace the collegium system, 99th Amendment Act was passed to give constitutional validity to this particular NJAC. But when the Supreme Court has struck down NJAC as unconstitutional, then what happened? Then, in that case, what happened was the earlier collegium system automatically was revived. So here also can't we apply the same test? In Minerva Mills case, if the court has struck down that all DPSPs will not prevail over fundamental rights 1419, then the earlier stance was what? 39B and C only should prevail over 1419 articles. That should be revived or not. This also court has to decide in this particular case. So I hope you got the entire picture. If not, you can just post your question in the comments. I'll be happy to clarify. Okay, so if you know this, the topic is almost done, guys. So I have to erase this aspect here, or let me just go to the, let me not erase it. Let me just go to the other aspect here, guys. So here, the bench is deliberating. I think already I told this point, so I can safely skip these points here, guys. Yeah, what is there on the screen? So you can pause if you want. I have already explained this aspect here, guys. Fine. Now, let us see what is this present case. Then you will understand it much better. For 39B, for the sake of common good, can I take even private property or not? There are conflicting judgments here in this case. First, try to understand what is Maharashtra case about. What happened here is the property owner association, like lot of land owners in Maharashtra, as we know, very populous state, very crowded cities. Okay, Maharashtra, in Mumbai is there. Okay, there we see a lot of times whenever the rainfall happens, old buildings, sometimes century-old buildings also are there. Dilapidated condition, hardly some small rents are there, very pittance. Those people are staying for decades in those buildings. Okay, so what happens? Many times the repairs are not done because they pay very less rent, and the builders and the property owners also don't want to repair the buildings. Routinely we see whenever rainfall, monsoon happens, these buildings will collapse and people will die. So what the government will do is, preferably before 1960, whatever the buildings were there, those buildings have to pay some cess. Cess here means the specified amount, a tax, kind of tax, okay? It should be paid for a specified purposes. Okay, so let's, what happens here? Cess. When I say cessed buildings means what? Those buildings which pay certain amount of tax, or we can say cess, to the government. Why? Because I'll tell you what happens here. Maharashtra Housing and Area Development Authority MHADA Act 1976 was there. In 1986, it was amended to say that state authorities will be able to acquire these cessed buildings and the land on which these buildings are there if 70% of the people who are staying there will make a request for restoration purposes. What if the builder is not repairing those buildings, even though they are in completely ramshackle condition, dilapidated conditions? So there what happens, because you pay certain amount of cess to the government can use that money and they can authorize the repairment board in Maharashtra, building repairs board. They can tell them, take this money, take over the properties and you repair this building. When? If 70% of the occupants will give request, which means you are a building owner, you are the land owner, property owner, and your building will be forcibly be taken away by the government by invoking Article 39 Clause B, because material resources can be distributed for the sake of common good, public good. Public good is here the people who are staying in the buildings which are quite weak in nature. So this act was brought for this purpose. That means state should create a policy that the ownership and control of material resources are distributed for the common good. Now this section 1 was there in this particular act, which is being challenged, that how can you take away our properties forcibly? After the repair is done, what happens is 25% of the compensation amount is of the land amount is given to these builders. So here the builders are like, how can you take away our property? It is wrong. They are saying that you are taking the property and not even doing repair work, and you are giving this property to the big land sharks, okay, or the big contractors. That is what is their concern here, guys. So let us see what cases are there in this particular issue. In 1977, a 7-judge bench has told that, okay, at the time Chief Justice M.H. Beg was there, in state of Karnataka versus Sri Ranganatha Reddy. In this case, what the court has told with respect to Article 39 Clause B. At that time, Karnataka Contract Carriages Act 1976 was brought by the Karnataka government, that they told all contract carriages like buses, okay, operating in the state, we can acquire directly, even if it is private also, taxis or buses. Court noticed that this question ultimately became the scope of 39B. Can we take away those carriages for the sake of public good? In 4:3 majority, 7-judge bench, they told privately owned resources do not come under material resources of community, and Justice Iyer has given a dissenting judgment in this case. He told that no, private property will also come under material resources. He did, but for a minority judgment, it was just a minority judgment, guys. But here 4 members have told no, private owned resources will not come under the aspect mentioned 39 clause B. Next case, 5 years later, guys, 5-judge bench has told in Sanjeev Coke Manufacturing Company versus Bharat Coking Coal. Coking coal is many times used for the making of steel, etc. guys. So what happens here? Coking coal is a raw material. So 4 union laws were there between 71-73 which told about nationalization of all coking coal mines and non-coking mines. Here the court has taken the dissenting judgment of Justice Iyer and told, yes, in this aspect of material resources of the community, it is not just natural or government owned material resources. Private resources also can be considered for the purpose of 39B. And they told the constitutional goal is to establish a sovereign, socialist, secular, democratic republic. So that means, I hope you understand, these 2 judgments are contradictory to each other. That is why the court has now gone for 9-judge bench. They have to decide whether 39 clause B, can we consider private property also as material resources? Can we acquire private property? Let me just, show here myself. I will just try to, The question before I end this session is 2 things. Will private property be considered as material resources of community? If yes, government tomorrow can take anybody's private property and say that for the sake of public good, we are giving the property to all. Second aspect, what about 31 capital C? The very basis for giving more importance to 39B over fundamental rights 14-19. Is it still there, or Minerva Mills case has struck down 31 capital C provisions completely, or shall we go back to the 25th Amendment 1971 which gave importance to only 39B and C? These questions are to be decided by the court. So let's wait and watch for the judgment. So I hope you understood this topic. If you have any questions, please post in the comments. I will see you another day with some other topic. Keep watching Amigos IAS. Thank you.